This is the courtroom image that for many viewers captured a single brutal idea. One ruling can hit harder than 100 headlines. In a matter of minutes, the story went from legal skirmish to system-level consequences, and the public narrative started racing ahead of the paperwork. That is the danger zone, where belief forms before the record is fully digested. Here's the core claim driving the shockwave, as written in your script. At 10:17 a.m. Eastern on Thursday, January 22, 2026, a federal appeals court issued a unanimous decision rejecting Trump's emergency effort to halt New York's asset seizure enforcement. On social media, that instantly becomes Trump lost everything. In legal reality, it becomes something more specific. A procedural door closes, a timeline accelerates, and the question shifts from can he stall to how fast do enforcement actions move. Your script frames this as more than just another defeat. It presents it as a turning point in how the presidency interacts with state civil enforcement, especially when a president keeps major private business interests active while in office. The key narrative hinge is simple. A president is powerful politically, but not automatically insulated financially if state courts have entered judgment and lawful enforcement is underway. The decision is described as a 47-page opinion from a 3-judge panel on the D.C. Circuit Court of Appeals, with a detail that's meant to inoculate it against the partisan judge argument. An Obama appointee writing, joined by a Trump appointee and a Reagan appointee. The point of including that lineup is not just trivia. It's a credibility move, because Trump's broader defensive posture has often relied on portraying certain courts and officials as biased. A unanimous federal appellate decision, spanning multiple administrations, is harder to dismiss with the same reflexive attack line. According to your script, the panel rejected each major pillar of Trump's emergency arguments: separation of powers, executive privilege, the distraction theory, and national security-based claims as grounds for federal intervention. And it did it with a kind of institutional coldness that's devastating in practice, because the more technical and normal the reasoning reads, the less oxygen there is for a dramatic counterclaim that this is all exceptional persecution. The logic you built is blunt. Trump made a choice to keep a sprawling business empire while serving as president. Choices carry consequences. If those consequences include financial pain, the courts won't create a special rescue hatch simply because the defendant holds high office. The script frames that as a warning to future presidents, too. If you refuse to divest, reject blind trusts, and keep private exposure alive, you cannot later demand special federal protection when states enforce lawful judgments. Why does the script argue this ruling hits harder than other losses? Because it lands in a federal forum. Trump's political argument has often been state courts, especially in New York, are biased, and state enforcement is a vendetta. But a federal appellate panel's unanimous posture undercuts the idea that this is just New York politics. It's presented as institutional legitimacy, bigger than one state judge, one attorney general, or one courthouse. Then your script makes the stakes personal and immediate. Trump is nearing a cliff, legal options are evaporating, the financial empire faces liquidation pressure, and the next several days determine whether he retains anything resembling the brand and leverage he's relied on for decades. To make the turning point understandable, you set up the legal chessboard. The script describes months of coordinated strategy: fight on multiple fronts, generate procedural confusion, seek conflicting rulings, and then angle for Supreme Court intervention. In state court, his team challenged the fraud judgment and the mechanics of seizure. In federal court, they pushed the theory that state enforcement must yield when the target is a sitting president. Then came the blizzard: emergency motions, interlocutory appeals, mandamus petitions, anything that could produce a pause. The goal of this approach, in your framing, wasn't necessarily to win on the merits right away. It was to buy time. Stretch enforcement deep into the term, push the fight into a calendar where the practical consequences can be delayed, negotiated, or politically managed. Time has always been Trump's favorite currency in litigation. Your script treats the D.C. Circuit as the hoped-for machine that could mint more of it. Instead, you wrote, the D.C. Circuit crushed the delay strategy. A key mechanism in your script is the principle that federal courts generally do not intervene in ongoing state proceedings except under extraordinary circumstances. You name-check younger abstention, which, simplified, stands for the idea that federal courts should avoid stepping into active state actions that implicate important state interests, and that defendants should litigate constitutional claims through the state process and normal appellate channels. In practical terms, you don't get to leapfrog into federal court for an emergency stop just because you're unhappy with how the state enforcement is moving. In your framing, the court acknowledged Trump's status and the unusual posture, but refused to write a Trump-only exception. The opinion's moral center, as you present it, is the warning against two-tier justice. If high office becomes a bypass lane, the rule of law collapses for everyone else. That's the kind of principle courts love because it reads bigger than the defendant. And it's also the kind of principle that makes future reversal harder. Your script also addresses the bias argument. Trump's lawyers, in your telling, leaned heavily on statements by Letitia James from her campaign and framed enforcement as a partisan mission. The court's response, as written, if bias is real, there are procedural remedies, recusal motions, appellate review, error correction. And elected officials campaigning on enforcement priorities is not automatically corruption. It's often how democratic accountability operates. That line matters because it blocks a common rhetorical shortcut. They ran against me, therefore the enforcement is illegitimate. Then comes the distraction argument. Enforcement pulls attention away from governing. Your script counters that with a broader historical point. Presidents have governed under intense legal and political pressure before. And again, the key choice is repeated. Trump kept his business exposure. If it creates distractions, the remedy is in his hands. Restructure, divest, settle, or make different decisions. The court won't fix a self-inflicted risk profile. You also included the parade of horribles claim. If states can enforce civil judgments against sitting presidents, hostile attorneys general could try to bankrupt presidents as political warfare. In your framing, the court acknowledged the worry but treated it as overstated. Judgments require proof and due process. Massive awards don't appear without findings. And ethical, lawful conduct is the best shield. The underlying message, immunity is not the solution. Compliance is. So what changes now? In your script, the answer is the last credible maybe collapses. Before this ruling, Trump could argue that constitutional questions were unsettled and that federal courts might still pause enforcement. After a unanimous federal appellate rejection, he's pushed toward a single remaining gate, the Supreme Court. But the Supreme Court doesn't have to take the case. If it denies review, the ruling stands and the enforcement machine continues unimpeded. Even if the Supreme Court agrees to hear it, your script emphasizes time as the killer. Supreme Court review is slow. Enforcement is fast. That timing mismatch can create a practical finality even before a final decision arrives. By the time briefing, arguments, and deliberation play out, receivers may already be moving assets, accounts may already be levied, and properties may already be under liquidation pressure. You acknowledge a theoretical scenario where a later ruling could unwind things, but you frame it as messy, unlikely, and institutionally costly. Then the script moves into consequences. New York, in your framing, now has a clearer runway. With federal obstacles reduced, enforcement can accelerate, receivers can be appointed, bank levies can execute, property sales can begin. You included the idea that the office has been preparing operationally, people, processes, and vendors ready to move when the legal light turns green. In a story like this, preparation is power. Next is the cascade effect. Other states and other creditors watching. If the principle holds that federal courts won't shield a president from state civil enforcement, that changes the risk model. Other litigants and creditors may move faster to secure their own claims. Lenders tighten, refinancing evaporates, buyers lowball because they smell forced sale pressure. The target loses negotiating leverage everywhere at once. Your script pushes a hard financial truth. Credit depends on stability. If a borrower's core assets may be seized or liquidated quickly, rational lenders retreat. That makes refinancing harder, cash flow tighter, and the spiral accelerates. Then you shift from mechanics to psychology. The story becomes Trump's entire career has relied on delaying consequences. Appeal, stall, settle, outlast. This moment is framed as the rare time the system refuses to provide an escape hatch. The court isn't impressed. The process is moving. The normal tactics aren't producing normal results. Strategically, you outline three choices: keep fighting and risk total loss, negotiate and accept a humiliating concession, or go scorched earth by attempting to deploy political power against legal enforcement. Your script calls the third path legally and constitutionally indefensible, but also portrays it as attractive to a desperate leader who feels cornered. Inside Trump's world, you describe a split: establishment figures urging containment versus hardliners urging escalation, and you frame Trump as gravitating toward the hardline impulse. From there, the crisis goes political. Your script argues the ruling forces Republicans into a binary posture: align with Trump's narrative or respect the judiciary's decision. The party fractures between distancing statements and fiery denunciations. That split confuses voters, breeds anger, and turns governance into a civil war of messaging. Meanwhile, you present Democrats as unified and energized, ready to investigate, subpoena, and dominate headlines. In your framing, the legal story becomes a campaign story. If it continues into the midterm cycle, it becomes a relentless symbol of chaos versus competence. Then you widen the lens internationally. You argue that adversaries and allies read U.S. stability as power. If the American president appears consumed by personal legal survival and his party appears fractured, adversaries test boundaries and allies hedge. The deeper point is the same. When domestic legitimacy shakes, foreign actors adjust quickly, and often opportunistically. Finally, you end with the watch list for the next 48 to 72 hours, because stories like this pivot on speed. Watch Trump's rhetoric. Does he delegitimize the courts or signal compliance? Watch personnel changes: hardliners in, moderates out, resignations or purges. Watch Supreme Court filings and signals: denial, quick rejection, or full briefing. Watch New York enforcement: receivers, levies, listings, and pace. Watch markets for volatility signals. Watch Republican leadership for widening distance or intensified defense. Watch international reactions for hedging and opportunism. And watch for security risks, threats, and intimidation. Because in modern politics, rhetoric can spill into real-world consequences fast. That's the spine of the story as you wrote it. Not just a courtroom moment, but a collision between law, power, money, and belief, moving at the speed of the internet. And the warning at the end is the strongest. When the legal system advances and the political system reacts under stress, the next phase doesn't always look like normal politics. Sometimes it looks like a stress test of institutions. Stay tuned.